Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today, we come to you with a six-pack of observations from last week. Last week contained lots of interesting news. 3 unanimous decisions last week told 6 different stories about the Supreme Court. Justices split on reasoning while agreeing on outcomes. Thomas identified another doctrine to repair, and Trump versus Cook saw rushed litigation play out in real time. So much to unpack from last week. Before we get going, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to get written rundowns. Just search the High Court Report. And if you have questions or comments, reach out via LinkedIn or email scotus.cases.pod@gmail.com.
Let's talk about last week's opinions. To learn more about the cases, check out earlier episodes. We release case previews, oral arguments, and opinion summaries. For whatever case you want to learn more about, search the High Court Report podcast feed or search for a specific case name.
Let's crack open that six-pack. First, we saw heavy unanimity, but with an asterisk. The court reached all decisions 9-0. So far, the court ruled 9-0 in 5 of the 7 decisions, or 71%. That's much higher than the approximately 42% unanimity rate from last year. To me, that signals that they're ruling on low-hanging fruit, clearing the backlog of uncontested cases. Expect that unanimity rate to drop.
Second, underscore asterisk with the unanimity. Despite a 71% unanimity rate, we see important fractures. In 2 of the 3 cases from last week, one justice concurred only in the judgment, meaning one justice agreed solely with the outcome, but not the rationale. In other words, I agree that Party A should win, but for C reasons, not D reasons. Let's look at the cases. In Berk versus Choy, the justices ruled 9-0 that Berk wins because Delaware's affidavit requirement conflicts with the federal rules of civil procedure. Authoring for the majority, Justice Barrett concluded that Delaware's affidavit requirement conflicts with Rule 8, which the majority says includes all the information a plaintiff must present about the merits of his claim at the outset litigation, namely, a short and plain statement of the claim showing that the party is entitled to relief. The majority says, by requiring no more than a statement of the claim, Rule 8 establishes implicitly, but with unmistakable clarity, that evidence of the claim is not required. Justice Jackson splintered with the pack. In her eyes, the court should have resolved the case on Rule 3 grounds, not Rule 8 grounds. Justice Jackson opined that Rule 8 does not purport to establish all that a medical malpractice plaintiff can be required to say about the merits of their claims. It instead addresses a more narrow issue: what minimum information a pleading must contain. Because the affidavit isn't a pleading, Justice Jackson found no conflict with Rule 8. She says Rule 8 does not address what information a plaintiff must provide about the merits of a claim. Rather, it governs how much a plaintiff must say concerning their claim. Justice Jackson instead found conflict with Rule 3. Here's her analysis. Rule 3 says a civil action is commenced by filing a complaint with the court. This rule conflicts with Delaware's law that requires the affidavit of merit submitted in order to begin litigation. Notably, all 9 justices agreed that Delaware's affidavit requirement also conflicts with Rule 12. So, why didn't Justice Jackson at least join for the majority's discussion about Rule 12? Especially since Justice Jackson's opinion said she sees no daylight between her and the majority on the Rule 12 conflict. Her opinion explains why. She felt that the majority's Rule 12 analysis drove to the heart of their disagreement. She said the majority's analysis centers on diametrically opposed characterizations of Delaware's affidavit of merit. She says the majority wants to have its cake and eat it too. For Rule 8 purposes, they label the affidavit a pleading, but for Rule 12 purposes, they label the affidavit as a matter outside of a pleading. Justice Jackson found this conflation untenable. Now, you may be wondering, what exactly is a pleading? Rule 7 defines a pleading as a complaint, a third-party complaint, an answer to a complaint, counterclaim, cross-claim, or a third-party complaint, and a reply to answer. An affidavit is a piece of documentary evidence that relates to a pleading, but as all 9 justices opined, it is not itself a pleading.
Let's return to this six-pack, unanimity with an asterisk, 9-0 result, but for two competing reasons. Justice Jackson joined with all justices on the outcome, and as we walk through some of the Rule 12 analysis. But she found strong enough reason to splinter in her rationale. Coney Island versus Burton also featured unanimity with an asterisk. Justice Alito wrote the majority opinion for 8 justices. Justice Sotomayor concurred in the judgment. Why'd she join only in the judgment? Especially since she said the court rightly reasoned the case on text and structure grounds. She said the majority unnecessarily opines on the potential validity of a constitutional due process challenge to the reasonable time limit. According to Justice Sotomayor, Coney Island never raised a due process challenge, and the lower court never heard a due process challenge. Therefore, she believed the court should have abstained from this analysis. Justice Alito explained why he addressed due process despite Coney Island disclaiming any due process argument. Alito found that Coney's argument must originate somewhere, likely the due process clause. In order to address Coney's bottom line argument, he had to first address whether Coney had a due process clause claim. Now, Justice Alito did not spend time building out this argument. That was Coney Island's job. But Justice Sotomayor felt it was unnecessary. So much so that she departed, except in the judgment. These splits foreshadow the court's approach to major constitutional questions. This term, justices telegraph their judicial philosophies through seemingly minor procedural disagreements.
Third observation from this six-pack, each justice to date, a separate justice has authored each majority opinion. 2 justices haven't yet written for the majority, Gorsuch and Thomas. Fourth observation, Clarence Thomas did write a concurrence in Ellingberg, which Justice Gorsuch joined. Justice Thomas wants to, in his words, restore ex post facto focus to focus the question of whether a law coerces a penalty for a public wrong. He believes the Supreme Court uses 2 flawed multi-factor tests that focus largely on whether legislatures label a law as criminal or civil. Under more recent Supreme Court precedent, the court wrongly carves out nominally civil laws from the ex post facto clause. That, under an original understanding of the clause, would fall under the ex post facto clause. Fifth, in recent months, I've spoken in at least 3 episodes about the ex post facto clause. Here's a primer on the ex post facto clause case law from Justice Thomas's point of view. The Founding Fathers considered retroactive punishment laws so fundamentally unjust that many believed constitutional protection unnecessary. James Iredell called ex post facto protection the most essential right of all, while Alexander Hamilton placed such prohibitions among the greatest securities to liberty and republicanism. Justice Thomas derives the original understanding from a 1798 case called Calder v. Bull. This case zoomed in on whether laws imposed punishment for crimes, terms with specific meaning at the founding. Crime meant any public wrong, offenses against sovereign authority prosecuted by the government, not private parties. Punishment meant any coercive penalty imposed to redress such public wrongs, regardless of how legislatures labeled their sanctions. Under this framework, ex post facto protection would apply broadly. Civil penalties for public offenses, administrative agency enforcement proceedings, and even municipal sanctions like speeding tickets may trigger constitutional scrutiny. The key test: does the government impose penalties to redress violations of public law? If yes, Thomas believes retroactive application violates the Constitution. Today's 12-factor balancing test allows legislative manipulation through clever labeling. Legislatures can evade constitutional protection by calling criminal punishment civil, placing sanctions in civil codes, and using non-traditional prosecutors like health agencies. Thomas argues this approach betrays the Constitution's purpose, preventing cruel and unjust retroactive punishment regardless of semantic games. The modern framework also creates unpredictable multi-factor balancing tests that invite arbitrary discretion from courts. Citizens cannot know whether laws constitute criminal punishment until judges weigh indeterminate factors with unclear weights. This uncertainty undermines the fair notice principles that motivate ex post facto protection. Thomas urges returning to Calder's simple test. Any retroactive law imposing coercive penalties for public wrongs violates the ex post facto clause, period.
There you have it. Thomas's concurrence continues his pattern from recent terms of using concurrences to attack established legal doctrines. He signals future majority opinions could abandon current constitutional frameworks when composition changes. The sixth observation from this six-pack actually goes to the Trump versus Cook case. I know it wasn't an opinion, but I re-listened to this oral argument more than once while snowed in with my kids. One major undercurrent involved the frenetic pace of the litigation. In oral arguments, we heard critiques of the United States and the lower courts about the rushed manner of the case. During the round-robin questions, Justice Alito asked,
"Is there any reason why this whole matter had to be handled by everybody, by the executive branch, by the district court, by the D.C. Circuit in such a hurried manner?" You began by laying out what you claim to be the factual basis for the for-cause removal, but no court has ever explored those facts. Are the mortgage applications even in the record in this case?
I know that the text of the social media post that screenshots to the mortgage applications is in the record. I don't recall if the paperwork itself is in the record, in district court's record.
So when this was before the executive branch, it was handled in a very cursory manner.
This mattered for two reasons. First, as Justice Alito pointed out, the parties created a scant, evidentiary, factual record for the courts to decide, not just the Supreme Court, but also the trial court, which initially heard the case. The facts drive the law. So, without clear facts, there's a risk that courts decide cases on guesswork and incomplete reasoning.
Second, this mattered because the lower courts didn't grapple with Cook's primary Supreme Court argument, an argument she marinated on and seared after the D.C. Circuit decision. Cook argued that statutorily, the statute implicitly requires a hearing. However, the D.C. Circuit decided this case solely on due process grounds, which was not Cook's primary argument before the Supreme Court. As a court of review, not first view, the Supreme Court generally disfavors requests to rule on issues that no court chewed on below. To me, this further signals a possible narrow ruling. Also, it represents an inherent danger of the emergency docket, where parties ask the court to rule preliminary on matters, almost always with a bare-bones evidentiary record. To cap off this episode, let's listen to one more clip on this topic.
There are two things were decided by the lower courts. One, that what I just explored, the district court said, got to be in-office conduct, nothing that happened before person took office counts. And then the D.C. Circuit said that your client had a property interest in her office, and therefore a due process right. Is that right? She had a property interest in being a governor on the Federal Reserve Board?
So I think there's a perfectly reasonable argument for that, but I also think that there's a better argument that's a constitutional avoidance argument. And what the D.C. Circuit did in a per curiam opinion is sort of an example of what happens when you're trying to rush all of this, which is you jump right to a constitutional holding when there may be a perfectly good constitutional avoidance statutory holding there. And I think we've now had a couple of months and a bunch of amicus briefs to ventilate some of these things. And I think you get, with that ventilation, you get an understanding that there is a very good statutory argument.
That be a basis for sending it back to consider these arguments in the first instance. If you are prepared to defend the due process argument and perhaps your frontline argument on that things that happen before employment are categorically and always off the table, why shouldn't it go back to reconsider it? You've advanced a lot of new arguments here. So have your friends on the other side.
That's my six-pack of questions for you. Thanks for listening. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Follow on LinkedIn to read rundowns. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email, scotus.cases.pod@gmail.com. Talk to you soon.